Good evening. My name is Ruchika Jain, and today I'm going to talk about winding up of a company and its lawful procedures. So now, what is winding up of company? So winding up is a way of dissolving a company or partnership by selling off all its assets, collecting any outstanding income, making sure that the creditors are paid from the proceeds, and distributing whatever is left. So now, whatever is left over may be distributed in cash or a kind. So initially to be preferred to the shareholders and then to the remaining stockholders. Now, in other words, it is a process by which a business or a part of the business is brought to an end and its property and assets are redistributed. Now, what are the different types of company wind up? So the companies can be wound up in two different ways. First is the voluntary winding up of a company, and second is a compulsory winding up of a company. So now, voluntary winding up takes place when a company becomes insolvent and is unable to discharge its liabilities. To carry out voluntary winding up of a private limited company, a winding up a meeting need to be called where a resolution is passed to carry out the winding up procedure of the company. The creditors winding up meeting should be held either of the days fixed for general meeting or on the next day. As per the procedure for winding up of a company in India, the notice for the creditors meeting should be sent by post to each other of the creditor while one is sending the notice for general meeting. It should also be published in official gazette and two newspapers which are popular in the district where the registered office of the company is located. A statement of affairs and list of creditors with amount due for each of them should be prepared beforehand and should be laid during the meeting. In case the resolution is passed during creditors meeting, a copy of the resolution need to be filed with the register within 10 working days from the date when resolution is passed. During same creditors meeting, a liquidator shall be nominated by the creditors. The liquidator shall be as per the regulation set by IBC Code 2016 and shall carry out all the functions related to winding up of the company. He shall prepare the detailed list of assets and liabilities of the company and shall also propose the process and timelines for liquidation. As per the Insolvency and Bankruptcy Code 2016, the fee to be paid to this liquidator is part of liquidation cost. Liquidator shall value, sell, recover, and realize all assets of the corporate person. He shall open bank account for purpose of receiving money from sale of such assets and will also administer the distribution of such proceeds with the stakeholders within 6 months of receipts of these proceeds. He shall also keep an electronic copy of these reports and will save them for at least next 8 years from the date of dissolution of the corporate person. Once the affairs of the corporate person are completely wound up, the liquidator shall apply with NCLT for its dissolution along with final report. The final report would consist of audited liquidation accounts and statements showing the details of disposed of assets and how they were sold. This final report also needs to be filed with ROC and board. Once this final report is submitted, NCLT shall pass the order for dissolution and the company shall stand dissolved from this date of NCLT order. A copy of this order needs to be forwarded to ROC within 14 days when the order was passed. So this is the process of a company winding up on a voluntary basis. So now let's talk about the compulsory winding up of a private limited company. Compulsory winding up takes place when a creditor of an insolvent company asks the court for a wind up. If the company goes into liquidation, the court of law appoints a liquidator for the liquidation. The primary objective of the liquidator is to raise as much funds as needed to pay the creditors. The company will then be dissolved and its name will be struck off from the list of companies in the registrar's office. Any surplus money left will be distributed amongst the shareholders of the company. This legal process ends with the company's name struck off from the list of companies in the registrar's office. after the name is struck off, the company ceases to exist anymore. Winding up involves the following. Every contract of the company, including individual contracts, are completed, transferred, or ended. The company is no more able to do businesses. Any outstanding legal disputes are settled. All the assets of the company are sold. Money owed to the company, if any, is collected. Funds raised are distributed to the creditors. Surplus funds left after all the transactions are distributed amongst shareholders. As per the provisions of Companies Act 2013, compulsory winding up is possible only under the following circumstances. When the company has passed the special resolution affecting the company be bound up by the court or tribunal. Second, has acted against the interest of the sovereignty and integrity of the company. Third, the company has defaulted in filing its financial statement or annual returns for 5 consecutive financial years. Fourth, tribunal or court believes that the company is conducting its affairs fraudulently or the formation of the company was for a fraudulent and unlawful purpose. Fifth, the tribunal or court is of the opinion that it is just and equitable to wind up of the company. The procedure for compulsory winding up of a company is as follows. The first step is the filing of a petition for winding up of a company, and as already mentioned above, the petition can be filed by only selected categories of person. The petition so filed has to be accompanied by the statement of affairs of the company. The petition should be advertised in the following manner. The advertisement must be carried out under Form 6. The advertisement should be in a daily journal at least for 14 days. The language of the advertisement should be in the regional language of the respective area and in English. The company needs to submit complete audited books of accounts. If the tribunal finds that the accounts are in order and all the mandatory compliance has been compiled with by the company, the tribunal will pass an order for dissolving, winding up the company. The registrar will issue a notice after the order of the tribunal to the Office Gazette mentioning that the company is dissolved. Was my speech on winding up of a company. Thank you.